Good morning. I think we can still just about say that. So welcome to this panel on GDPR and new technologies. My name is ChristophLuykx. I am a policy director at ORGANISED. Now, for people who don't know ORGANISED, just a quick word on that. So we represent Europe's technology industries. So basically, we represent a lot of the manufacturing, the hardcore industrial base here in Europe. And so a lot of those industries are transforming because of a lot of the digital transformation aspects. So they are dealing a lot with new technologies also. And so that's why I'm really happy to be here as the moderator of this panel. Just on kind of maybe quickly, what do we all want to get out of this panel? What are the objectives? I think obviously the context is such that we have the GDPR. We have now some experience with the GDPR, and we have new technologies. And so the question is, with the upcoming review of the GDPR, are there things that we can already say about some of the lessons learned about how new technologies are challenging the GDPR? Is it able to handle it? If not, what are some of the gaps? So I think that's kind of the objective. And I would like to, at the end, maybe that we have a couple of points, maybe 3 points that we say, the GDPR is really good in handling new technologies because of 1 or 2 points. But also there are potentially a couple of gaps that we will need to address to make it even more resilient with regards to new technologies. And so what are those 1 or 2 points that we will need to focus on? Now, you will see, or you won't see slides. So you will see that I'm not a fan of using slides. And so I'm really happy that the panelists all kind of like responded and respected that. So what I do want is an interactive discussion, interactive amongst ourselves as a panel, but also with the audience. So I will turn to you also for some questions. So I'm not a fan of opening statements. So I've kind of changed it to opening questions. So I will ask everybody a different question, which basically will also set up a little bit the discussion. And I think the themes that I want to touch upon, just so we know that, obviously talk about the GDPR, the fact that it is technology neutral, question mark, is it not? If it is, what does that mean? What are the good things about that? For example, dealing with new technologies. But there's also the point about, that means also maybe we need a lot of guidance with regards to the GDPR. I also want to touch upon kind of the global impact and the link to other pieces of legislation in relationship to the GDPR. And then the enforcement part, that will probably also come up. So those are a couple of the themes. So enough for my intro. I just want to turn maybe towards the first question. And I think it's good to start with Carolina from DG Justice, because obviously of the context we mentioned with regards to the upcoming review. So let's start with that. So Carolina, thank you again for joining. With the upcoming review, can you say a couple of words on the process? But also, is there already maybe some initial thinking from DG Justice with regards to the review and the aspect of new technologies?
It's on, yes. Hello, everybody. So, concerning the process, we started to gather views from different stakeholders, which I already partially mentioned in Article 97. And we are reaching out also to some other parties which are not directly mentioned. So, of course, we will have the views of the Council, which were, by the way, adopted just yesterday by the Council, and the opinion of the Council concerning the evaluation and the review of the GDPR. We will have views from the European Parliament, from the European Data Protection Board and data protection authorities. And here we reached out to the VIA board, to data protection authorities. We will also have the views from stakeholders in the meaning of businesses, NGOs, universities and professionals. These views will be gathered via so-called multi-stakeholder group in which, for example, Anna is participating, which is very representative as far as this, as the views of the stakeholders gathered in this group are concerned. So we have an equal number of businesses and NGOs or civil society, and also then the legal professionals and universities. What the review or this evaluation will focus on is already provided in Article 97 itself. It's international transfers, so Chapter 5 and Chapter 7, cooperation and consistency. Of course, and you will probably see, or maybe you have seen already the position adopted by the Council, issues concerning new technologies will be mentioned. But so far, the views we have received were that by no means the GDPR should be opened, so that this technological neutrality of the GDPR, which you mentioned, it's big enough in order to encompass the new developments which we see on the market. And of course, everybody's thinking about artificial intelligence possibilities, as announced by our new president, possibilities of data sharing and technologies like blockchain. So I think this would be that from my side.
No, that's a perfect scene setter, I think, for the ongoing discussion. I told you, and I warned you, that I like interactivity, so I'm actually already going to ask the audience a question. If you're in favor of opening up a review of the GDPR, can you raise your hand? I think it's fair to say that the majority is probably not in favor. We'll come back to that later. Thank you. So maybe let me turn to the only, let's say, corporate representative on the panel, William. So William, the question that I have for you is, what are your experiences with the GDPR and dealing with new technologies? Maybe you can give an example of your experience, and also maybe a couple of words on kind of the global impact you've seen on the GDPR and what's happening across the world. Has it had an influence on other parts of the world? And we'll come back to the technology neutrality point later, an interesting one.
Okay, thank you for that, and thanks for setting up this great panel and discussion today. Starting with the issue of the impact that the GDPR has had on Google's development and launching of new technology, I would say it's on the whole overwhelmingly positive, right? I think when I was talking with a colleague in the way here, they mentioned the analogy that when you put brakes on a car, the car can go faster. And in some ways, that's our hope for technology, that by putting checks and brakes in place, by forcing organizations to pause and reflect, and making sure that they're complying with rule sets and principles in a thoughtful way, we are in fact supporting and enabling responsible technological innovation rather than inhibiting it. So I think on the whole, it has been a positive thing. Google was already starting, I think, from a very high standard in terms of its privacy governance program, but there's undoubtedly a huge amount that we've layered on top to meet the requirements and challenges of GDPR. And I think many of those structures inside Google are privacy review structures, or specialist privacy working groups that look at specific product and technological issues, have really started to bed down, and I think in a very positive way are providing that break or that pause so that we can reflect on technological evolution at each stage of the process. So I think that's been positive. I do think there are still areas of opportunity. Those areas of opportunity don't necessarily require new regulation or legislation, but I wouldn't rule that out either. And so those areas are the GDPR is, of course, technology neutral, but it's not data neutral, right? It has special rules around processing of biometric data, sensitive data, and in the context of AI, figuring out how that works within the context of research exemptions, figuring out what's socially beneficial is challenging. And I think there's opportunity there to use some of the mechanisms in GDPR, like codes of practice, certifications, and seals, to really deliver on the promise of GDPR for users and for technology. I think turning to the second part of your question, which is really about the impact of the GDPR, I think there I would say two main things. Firstly, Google as a company has tried to adopt a consistent approach globally where that's possible. So in a lot of our public-facing user tools, like My Account, like My Activity, which shows you all of the information you hold within Google services, these tools, many of them began in the origins of a European conversation, but are now available to users around the world. And I think that's a tremendously positive thing. Of course, there are some areas where we can't apply standards globally, where questions of speech and privacy fall to be balanced differently. You wouldn't expect us to apply that normative reality in different parts of the world in the same way. But where we can, we've tried to adopt the GDPR standards globally. I think the other piece I would say is that, of course, that quest for interoperability and adequacy that other countries have, and the excellent work that the Commission has done in promoting that interoperability around the world, have meant that we're seeing from California to India to Brazil to Korea, many of the elements of GDPR start to filter through into other legislation. And again, that gives me a great amount of encouragement that we will move slowly towards interoperable privacy laws that will allow technology platforms to flourish on a global basis, whilst recognising that there will always be local rules of the road in relation to some issues.
Great, thank you. And actually the question I asked earlier, on the panel, who thinks that we should actually open it up for review? Maybe DG Justice can abstain, I don't know if you want to, but who wants it to be reopened? Nobody. Okay, consistent.
I don't think not raising my hand means I'm voting in favour.
Okay.
It is a privacy conference. I think I'll wait and read the I think I'll wait and read the report, and then I'll make a decision about whether or not we think that elements of it need to be reopened. But I think we're still in information and fact gathering mode at this point.
Yeah, and we'll of course try to identify some of those facts, like where are the gaps. So we'll come back to that. Anna, you're representing EDRI. So from a civil society point of view, your thoughts on the GDPR, has it been able to deal with new technologies, or are there gaps?
Okay, thank you for having me here. And yes, I represent the European digital rights, and as probably everybody knows in this room, we are an association of digital rights organizations fighting for human rights and other protections in the digital environment. So I'll address it from this point of view. I think one thing that we must remember why we're having this discussion in the first place is that new technologies such as artificial intelligence can have a real impact on society, both in the good way, but it can also cause real harms. And there are many examples of bias and how this can happen, particularly for the most vulnerable in society. In terms of what we should do with legislation to address that, my main foremost message is do not tamper with GDPR. It took in terms of privacy and data protection, it took blood, sweat and tears over 4 or 5 years to get it on the legal statute books. It's not the most perfect legislation, but it is the best we've got. So that's my first message. My second message is the biggest gap that we have is enforcement. It is a technologically neutral piece of legislation. It's principles-based. The 3 main principles of accountability, transparency, fairness. Every time I read a set of ethical guidelines, they all mention these three principles. They're already there in legislation on the EU level. There's also a lot of articles in it that support these principles. And what we are missing is maybe a body of proper guidelines, because a lot of the articles are still vague and need explaining. And unfortunately, some of the guidelines are more complicated than and lack understanding than the actual articles. And maybe one improvement that is needed is how we have guidelines that are understandable by everybody, because at the moment, you know, they might differ between national regulators, they might be too complicated. So that would be my main and first message. Enforce it, do not tamper for it, and by all means have a review in the way that it was just explained, but not a wholesale tampering.
I think that's clear. Good. So we've talked, you know, we're focusing on the law, the GDPR, and we focused on technologies. And then, of course, there is the factor that we shouldn't forget, which is the human aspect. And so, Mireille, maybe asking you the question. So what are some of your thoughts on, you know, what we were just discussing, but also taking into account the human dimension in this debate between law and technologies?
Well, thank you very much for this question and for inviting me here. In a way, I'm a bit surprised about the question, because law and technology is, of course, all about humans. Law is created by human beings. It aims to coordinate and regulate interaction between humans, and technology is also created by humans. And let's hope it is created to serve human beings and their interaction. To go to the GDPR, I think, other than some others, that the GDPR and even the Data Protection Directive was very forward-looking and had a very good anticipation of the kind of technologies that have been rolling out. And I'm, of course, thinking of Article 22 of the GDPR, which gives the right not to be subject to automated decisions. And I think that's a very crucial right, especially in the light of all the different types of automated decision systems that are being rolled out in basically all contexts of our society. Interestingly, in the Data Protection Directive, that was primarily applicable to what we now call profiling technologies. At this moment, under the GDPR, this also applies to, let's say, deterministic decision systems. So a lot of the decision systems that are used by governments fall under Article 22, and the whole range of blockchain technologies, as the interesting article of Michel Fink shows, basically falls under that right not to be subject to, which the EDPB has interpreted as a prohibition. I think this is an extremely important right that has to be given hand and feet. It's a right that protects individual persons, human persons, us, we, but also groups of people and categories of people. So categories of people that are treated the same way based on a certain algorithm, who may not at all know each other. I think to flesh out the implications and the consequences of Article 22, we have to move maybe a little bit faster towards enforcement. And my favorite article in the enforcement chapter is Article 79. It's an article that nobody talks about. I keep tweeting about it and mentioning it everywhere, because actually I think once we start using Article 79, we will get to move on with the reality of the GDPR. So what does Article 79 say? It says everybody has a right, and member states should take care that that right is effective. Apart from your right to go to the DPA, to the supervisor, to make any unlawful processing stop. and to go to a court to get that done. So basically that means an injunction. Now imagine if you think that some company or government is unlawfully processing your data. You can go to the supervisor, complain about it. It might take some time. But you could also go to a civil court, basically, and tell that civil court that this is a tort that is happening and that you're asking an injunction, that means an order, to stop unlawfully processing your data. Contrary to Article 82, which gives you a right to compensation, which means you have to prove damage, very complex. Contrary to Article 82, Article 79 I mean, can be brought, has to be possibly brought under collective action of Article 80. So that means you can group people together, go to court and say, I want you to give an injunction to stop unlawful processing. And that means the court can say to a company, if the court finds it is indeed unlawful processing, for every day that you do not demonstrate compliance, you're going to pay, what shall we say, 200,000 euros, 400,000, 1 million for every day. This is far more effective than a fine or damages. And I'm waiting for the moment when public litigation picks this up. I have more to say, but I think I will leave it to this. For now.
So let's focus on the point of enforcement, because I think it's an interesting point that you mentioned. So far, that has not been used. No. And what's the reason why that has not been used? Are there thresholds? Is there a risk? I mean, is just the burden also of proof an issue? What is the issue? Why we have not seen that yet?
Well, if somebody could tell me that, I'd be very curious, because the burden of proof is different, less than under a tort action where you want damages. And we all know that the DPAs are understaffed. I can imagine that this is a very different type of approach that maybe is not in line with what is regularly tried, but perhaps people in the audience or Adri has an idea why this is not being tried, because I do believe...
Well, one reason could be, of course, that there is no unlawful processing, but I'll leave that in the middle. Anna, you wanted to comment on that?
Yes, just a comment on that, because that's the judicial review injunction article, right? If we're getting into this kind of detail, I just wanted to make a comment. In order for that to happen in the first place, there's a lot of proof already around. There's been a lot of research and documentation, including by NGOs. Only last week, the Norway Consumer Council published a really detailed report on the ad tech industry that shows massive infringement of the regulation. So what's happening, you've also got Article 81 and 2, whereby NGOs can take action. And I do agree with Mireille that having litigation is an effective way of enforcing it, particularly strategic litigation. But you have a lot of the infringement that are hidden under the bonnet and apply to thousands and millions of people. But in most countries, the right for collective action hasn't been implemented. So you have people relying on litigation representing one or two users or consumers, but you don't have an effective way of litigating for this kind of issue.
Yeah, a very short response, Mireille.
Yeah, so if you want damages, Article 80 says this can only be done via collective action if the member state has enacted that. Yeah. If you do not want damage, that right is given to you by the GDPR. There is no clause qualification.
William.
Very important.
Yeah.
Perhaps just there is clearly a role for enforcement in applying the principles of the GDPR. And I think on ad tech, specifically to your point, we have open statutory inquiries into a number of data controllers, including Google, which are working their way through the process. The UK ICO has published a series of reports on the operation of the ad tech industry, and the ad tech industry is responding and engaging in that process. I am the first to acknowledge and actually support the rights of individuals to take individual action, either by complaining to data controllers to get a better result or by litigating. But I think one of the things that I would ask us all to think about collectively is to really deliver on the promise of GDPR, we have to scale its impact, and we have to scale it in meaningful ways. And I think interpretative difference within sectors or within how we deploy GDPR principles and technologies, there's a tremendous amount of machinery in the GDPR. In fact, there are more articles on seals, codes, and certifications than enforcement per se. So I think if we are covering the full gamut of the GDPR's intent, we have to recognize the role for strong enforcement, certainly. We have to recognize that individuals should have rights of action, but we also have to recognize that there's an opportunity for privacy advocates, for companies, and for sectors to come together to define rules of the road in ways that are scalable and that actually have an impact on more data subjects over time. So I think it's a mix, right? I don't think it's enforcement or litigation or codes. I think it's a mix of all of these things, and I just want us to kind of take account of the full picture as we think about how to scale the impact of the GDPR for users.
Well, but I would also draw attention to the fact that being technologically neutral and resting on the principle of accountability, so putting a lot of responsibility into the hands of controllers, the need for effective efficient enforcement is even stronger, because then, bottom line, the compliance controllers would have higher costs than non-compliant ones. So already from this point of view, the enforcement is crucial, and I wouldn't say that. I would say that the push for the enforcement, rebalancing accountability and this openness of the GDPR is very clear. We have harmonization of powers of the DPAs, imposition of fines which can be of important amounts, and this clear parallelism of two venues, DPAs, data protection authorities, or courts, without the graduation there that first the DPA and then the court. So I think, yes, GDPR is an expression of a balance, but for me it's a balance between openness, accountability principle, which is rebalanced precisely by enforcement so that the compliance pays off. Because otherwise, all the investment made would not work. And from the point of view of data subject, it's sometimes difficult to follow and to trust in the digital economy, knowing that the controllers would need to be really verified by one.
I strongly agree with that. I think, you know, at Google, we made a huge amount of investment in GDPR compliance processes and systems, and we absolutely that rests on the principle of accountability and being a responsible data controller. So I completely agree that we need to have enforcement as part of that mix. But I also think that we all collectively have more work to do on delivering of the promise that was set out in the GDPR for the deployment of seals, codes, and certifications. And I think that includes industry too.
If I may, but indeed, I mean, speaking about this openness and technological neutrality, and going back to maybe they need to precise and put a little bit of flesh on the bones of some principles or on terms, I would think that this is then again rebalanced not only by the guidelines, but also by certifications and codes of conduct, which give the controllers a little bit more of legal certainty in this quickly developing environment, where the GDPR gives the tools to provide for legal certainty, but maintaining the flexibility, because the codes of conduct can be revised much quicker than a legislation. The certifications can develop with a much quicker path than it can happen with the review of legislation.
So maybe before I turn over to Anna, I just wanted to ask the audience, because we're transitioning between a couple of topics, and I also want to throw in, we're talking about enforcement, and it's not a GDPR only panel, it's about GDPR and new technologies, of course. The question is, what are some of the challenges with regards to enforcement and new technologies? I think one of the things that I've heard in the past is, you as a consumer, you don't really know how these new technologies work, and I think even DPAs are also sometimes challenged about, you know, what is happening behind the scenes on these technologies. So the question I have for the panel is also, what's specifically the challenge with new technologies? Let's use, and we've gone, whatever, half an hour through the panel without saying AI, I think, but let's use AI as an example. Where is that challenging the enforcement part? But I would like to ask the audience, think about one question you might have on enforcement, and then you can go up to the microphone. But just on that question, for example, use AI, why is it challenging the enforcement part or not? Anna?
Well, I was just about to, you know, intervene in this very useful debate, which is very good but theoretical. And linking enforcement with new technologies, you know, look at what's happening in reality. From the evidence we have and from our research, we see a lot of companies, and we had this discussion before, William, they take the low-lying fruit, you know, things like privacy policies, which are still unreadable, by the way, things like, you know, data subject acts and, you know, how to provide access requests. But the real technology issues, you know, take as an example, you know, and I'll use Google as an example since William is here, so we can have a discussion. You dominate the Android mobile market, 75% of mobiles. The research by my colleagues last week showed that in that environment, you've got on this Android mobiles a Google ID cookie thing that gets and identifies to hundreds and hundreds of media companies. That is a new technology. It uses big data, it uses analytic, detailed profiling. There's no way for users to know that Google ID is there, and they can disable it, but very few of them know. How do you, and it contravenes the GDPR rules, how do you deal with that in a practical way? Do you get consumers to read 300 privacy notices of all these media companies? They don't even know they exist there. So this is a very practical question, and a question that the technology poses.
Good point. I think it's logic that I go to you now, William.
Wow, where to start? There's a lot to cover. Let me start with directly addressing your comments in relation to Android, because I think that's important. Android's a very vibrant, kind of open mobile ecosystem. We do have a range of standards in place to require those who place apps on the platform to put privacy policies in place to comply with rules and standards. And we can go into more of that offline. We're very limited in terms of the panel today. And we've invested a lot in our app permissions model so that users are aware of where data is being shared with apps. The ID you reference, of course, is our ad ID. It's if you go to your Android control, you can reset it at any time. And that's important because prior to that ID and a similar ad ID being introduced on Apple products, there were practices in the market which were undesirable, like fingerprinting, where users weren't aware of what was happening. So the principle of having a resettable ID was something that was very important and was positive for privacy. So I think we are doing a lot in that space. I'm not saying we have all of the answers or the solutions. We all obviously study each report very carefully, and the product teams are looking to see where they can do more. And we invest a huge amount in user research, in design research, in speaking with users and trying to understand how they engage with technology. The ecosystem is complicated, and I think there is a responsibility on Google and those who operate apps to do all they can to explain and help users navigate that. And I think, you know, at Google we're doing our part. So happy to pick up offline and share more details of how we're making Android and the app ecosystem safe. To turn to your attempted pivot to talk about AI and technology, firstly a plug for the Google stand. We have a stand. You gave me the opportunity, so I'm taking it, covering the our AI principles outside. So if you want to learn more about Google's approach to AI, please go and visit that, or the Google panel after lunch will also be going deeper on these issues. But we've set out our responsible AI principles. We've set out areas where we see kind of no-go areas or red line areas, and I think that, you know, is a kind of very good thing to do so that people understand where we stand. But we haven't just set out principles. We've also published what we're doing internally to practically implement that and put that into effect. So I think we've done a lot. Last point on the GDPR and AI, I think the governance and review processes definitely enhance the review position and help us get to better solutions and outcomes when we deploy AI technology. I do think there are interpretative issues around scope of research exemptions, Article 22, which came up before. The interpretation of that as a blocker rather than a right, I think, is an interesting thing. Which will no doubt there'll be future debate on. But I think the opportunity is there when we're looking at AI solutions to use mechanisms, and I return to it, like code certifications and seals for sector players to come together and try and define the GDPR rules in a way that is absolutely protective of privacy, that has data protection principles at its core, but also enables responsible innovation that will benefit society. And I think the GDPR does provide that opportunity and that path, but there is continued work to do to make sure that we're deploying things in a safe and scalable way, and that everyone's on the same page with regard to how the rights are interpreted.
Okay. So I want to, is there any question, somebody in the audience, on enforcement specifically, based on what has been said? I don't see anybody walking up to the microphone. So I think to kind of summarize a little bit this part of the discussion, I think what I hear is GDPR has a range of tools with regards to enforcement. There is a lot of happening. There is maybe some gap with regards to, I'll say it again, Article 79. But there are different tools. But I think one of the points that will keep coming back is transparency and understandability, explainability of technologies. So I think that's going to be something that we'll have to probably address in the review also, like how the GDPR could further enhance that. I don't know, Carolina, do you want to make a point on that?
I think Article 12, 13, 14 are very clear in this respect, and also provisions concerning consent. What is an informed consent? So I think the obligations are already out there. The question is how they are being complied with, and whether all these new technologies are also used so as to provide in new innovative ways the information notices, yeah? And how to ensure, because the obligation is clearly on the controllers, how to ensure that the person was informed, received the information, and understood, in the case of consent, what it was, what he/she were agreeing to. Yep. And this is already there. This is an obligation. Of course, it is worded in a very open way, very result-oriented way, which allows deployment of different ways, technologically neutral, but always with a clear message. You, controller, you have to ensure that when you have a consent, the person from whom you got the consent understood what it was. Always adjusting to the age of the person and, context within which the consent is being required.
Yeah. Mireille?
It's a big challenge, but,
Mireille.
Yes, so I want to say two things. So the whole ad-driven market, we now have ad-driven content, and we've seen what are consequences of living in an information environment with ad-driven content, where an algorithm calculates what sort of content increases your ad revenue. This we cannot possibly want. So an economic market that is constituted such that this is the incentive is not the sort of economic market that is conducive to democracy. Now, I want to move out from the GDPR. Yes, I think that the GDPR, if it gets enforced at this point, because the consent structure around Android and other AI-driven systems is spaghetti for data subjects, so it's unmanageable. But I want to move out from the GDPR, and I also want to move one step away from even personal data. And I think the solution that I want to present to you will also reinforce the GDPR in data protection. We know that the Machinery Directive, that is a directive that determines whether you can put an application on the market. It's the CE label. It also determines whether you can import an application onto the market. We know that that's under revision because the idea is to bring AI under that. Now, I would propose to the European Commission to take a very daring step and to say, anybody that puts an AI machine learning application on the market has to pre-register their research design. That means you don't have to show the precise data you have used, but the type of data, the volume, where you got it from, why you think it makes sense, which algorithm you used, what feature space you developed, what hypothesis space, what performance metrics, etc. This is all mathematics, actually. That should be pre-registered in an open environment, Open Science Foundation or whatever, Open Science Framework or whatever, comparable to what people who develop a drug have to register before their publication is published in serious scientific research. We're talking about airplanes. We're talking about toys that are built increasingly with automated systems, increasingly with machine learning. It is imperative for our physical safety, and that's what the Machinery Directive is about, that we know when systems are p-hacked, when the system, the application is basically crappy. I always say that 95% of the applications that are now around, that are to a large extent software, but that are moving fast into robotics, Internet of Things, etc., are crappy. Most people look at me like, how dare she say that? Most people who know something about these systems say, yeah, of course. Yeah. So I would challenge the Commission to attempt this and couple it with an update, of course, of the Product Liability Directive, bring these sort of applications under it to ensure that whoever puts an application on the market that causes harm, and I would like to see a broad scope of what constitutes harm, must be able to show. Now, I like to see the advertising intermediaries, who are the only ones that are making money here on the advertising system. This is coming out increasingly. Neither the publishers nor the advertisers are gaining from the system. There's scientific research on that now, that they have to show their cards. They don't have to show trade secrets. They don't have to open up their IP rights, but show the research design. And I think this will have an enormous impact if it is enforced and coupled with strict product liability on this market. And we really need that.
So just because we have 10 minutes left and I want to touch upon one or two other topics. This was a topic I wanted to touch upon about the GDPR is one piece of legislation. There are other pieces of legislation that are meant to address technologies, Machinery Directive being one. And by the way, we're very active on the Machinery Directive, and there is an IMCO hearing this afternoon on Product Liability Directive. So we're very much focused on that. I might have some different views on that, but as a moderator, I'll stay a little bit out of the debate. So Machinery Directive is one, Product Liability Directive is another one. And a final point on this one, and then I want to move to technology neutrality.
I think what Mireille brought forward is a very important point. I mean, the idea she proposes sounds very interesting and worthwhile, But deriving from that, there's a whole body of EU legislation that could apply to new technologies. I mean, we've got human rights laws that have a direct impact, and we haven't looked exactly how they're applied and how they're enforced. But equally importantly, if you look at consumer protection law, you have the Product Safety Directive. It doesn't include software. You have Internet of Things, Internet-connected devices with software that is not protected under any legislation. So that's where it should be mapped and analysed and see where we need changes to apply to these technologies. Liability laws, if you have machine learning, who is liable? The developer, the company that uses the system afterwards. All these things need to be looked at in detail, and that's
literally 10 seconds, because I know you want to move on. I would just say that for Google's part, we are very supportive of AI principles and AI regulation. Our chief executive made that clear in Brussels this week. I think the job is to work out exactly as the panel's pointing out, where is the delta? Where is the risk or the harm that is not already regulated that we need to mitigate? And I think GDPR covers a lot. I'd be the first to say not all of it doesn't apply to non-personal data, for example. So I think there's a job to be done in kind of working out what is GDPR already doing, and then where do we need additional principles to be set down. You know, when you were talking, I was thinking a lot of the things you were describing in that document sounded like a privacy impact assessment we would do under GDPR. So I think there's a job of work to say, well, what are companies doing already? And of course, privacy impact assessments we're accountable to regulators as an accountable controller in relation to those. So I think, where is the gap? And then we look at the gap and take it from there.
Okay, so question for the audience, for everybody actually. So about technology neutrality, who believes that the GDPR is actually technology neutral? Raise your hand. That's interesting. I would even say I saw maybe 50%. So a lot of people still think it's not technology neutral. So I actually didn't look at the panel. Who thinks it's technology neutral?
What do you mean with it? It has three very different meanings, so I can't answer the question.
What are the different meanings?
Well, one meaning is to say if a technology changes the substance of a right unintentionally, then the law should compensate for that, otherwise the law is not technology neutral. But that's not what you mean. You probably mean that the law should prevent some sort of technology from being advantaged in a way that we don't want certain companies to have an advantage because they have just invented that.
So it's a good point, and I should have clarified. So when I talk about technology neutrality, is that the law itself doesn't try to deal with a specific technology. At the time that we were debating and the blood, sweat, and tears, so that's how I understand technology neutrality. It didn't talk about AI or IoT, I believe. So
exactly, it's the way we will understand it. That it does not promote or it's not to advantage of any concrete technology. Indeed, it frames the use of data within any possible technologies. Yes. So.
And so the follow-up of that is that a strength? Meaning, is it then able to deal with all of these different new technologies coming up? Or is there also a weakness in that it is maybe too vague and raises a lot of questions on how to deal with new technologies? Any thoughts from the panel on that kind of balance?
Well, Maria, go ahead.
I think, yes, the law is designed to be and is technology neutral. It clearly has different standards in relation to different sensitivities of data, being an instrument about personal data per se rather than technology. I think the flexibility inherent in the principles, it is its strength, and I think it is for responsible, accountable data controllers, courts, data protection authorities, and I'll say it again, industry sectors through the machinery that's in GDPR around seals to put practical flesh on the bones around that. So I think, is the GDPR technology neutral? Yes. Can we do more collectively to ensure consistent application and clear up confusion about the application of rules? Sure, I think we can. So I think the promise is there, but there's still work to do.
Anybody else?
Well, of course, the Commission's view
You go first.
is, yes, it is technologically neutral, and it leaves space, but provides for responsibilities. And it induces, because we were speaking about accountability principle and so on, it's based on the risk-based approach. So it's a little bit like, do what you want, but certain things cannot be done. So it protects, really. This is the basic discussion which we had in the beginning, during the negotiation, during these terrible years, how to find a balance between protecting the fundamental right and giving possibilities to the business, and not shaping or channeling the development and innovation into one way, because maybe we then would exclude something that would be very desirable. It serves to protection of fundamental right, point. And then go and play with it by also inducing, and this is what I wanted to say in the beginning and I got lost, accountability, risk-based approach, but also data protection by design and default. It's the reason. It's not cutting off on the innovation. It just says, when you innovate, bear it in mind. Yeah? So the concrete already tools which are provided for.
So Anna, and I also want to give anybody in the audience to raise a question that they want to raise. So think about it and move over to the microphone, please.
So I broadly agree with that. If you have a number of principles and then certain flexibilities, clearly it would apply to a number of issues, new technologies. The challenge afterwards is to decide and see how can you apply those principles to different sectors. How do you apply those principles to facial recognition systems, for example? And if you can't, and if it's not possible, what are the sectors which have effects that are not permissible in the first place? So it's a balance between that. But if you have something based on principles, they clearly can be applied to a number.
Yep. William, and then I want to give the floor for the question.
The GDPR is technology neutral, but it's not neutral on the question of whether or not technology should be part of the solution to privacy. That's inherent in the notion of design and default, right? And what we haven't talked about today are all of the privacy-enhancing technologies that GDPR encourages, which can actually enhance privacy, like differential privacy, federated learning, and the right. So I think it's both technology neutral, but supportive of technologies that support privacy.
Great, thank you. Can you please introduce yourself?
Yeah, Tobias Moschus from Datenschutzraum Germany. My question is on the enforcement in case of reuse of data. So if we look at a very recent case, we have someone that gathered a lot of information from Facebook and then used it to supply the police with an application for face identification in the US. But how is this? How is the enforcement with such stuff, especially if the legislation is trying to get access to more and more data, like data collected at home and so on? How do we enforce at that point?
Anybody wants to take that one?
I'm not sure I fully understood the question. The rules for use and reuse of data are provided for in the GDPR. Tools to enforce the GDPR are provided for in the GDPR, plus national procedural rules, in particular in front of the DPAs, data protection authorities, or then the national courts. So what can be done and under which condition data, personal data gathered for a concrete purpose can be reused, it's provided for. Yeah? One of the conditions, one of the legal bases from Article 6 needs to be complied with. There must be, this is the toolbox. When whatever you do in the European Union with personal data, you need to have one of the tools from Article 6, plus if it's a sensitive data, Article 9, and so on and so on. So yes, this is all regulated.
What is if the controller is not in charge of the reuse? So if someone else is reusing it, or some state is trying to get the data?
Well, the question is that on which basis the controller already provided third person with the data, because providing a third party with the data is the processing, and on which basis the third party is processing the data. It can be that it's provided for by the legislation, and that the controller, while gathering the data, for example, on the basis of contractual obligation, also needs to submit this data for, I don't know, some kind of due diligence. I think here in particular about money laundering directives and so on in the case of banks. So this is provided for. The point is that nobody can have personal data in the EU without having a legal basis for it, and and without having applied the GDPR.
Short comment, Maria?
Yeah, very shortly. It's going to be boring, but I still think it's very important. So one can give a very elaborate answer and send people to the DPA, but I really think it is important that in cases where it is clear that under the GDPR processing is unlawful, that people should get together, go to an NGO in line with Article 80 and 79 and go to a court and ask an injunction. And this might push the court to ask the question about whether this processing is unlawful to Luxembourg, but it might go much faster than via the DPA, etc.
Okay. Any other questions from the audience? Can you maybe move over to the microphone? Oh, there's 2 questions. Yeah, very short ones then, because we have to wrap it up.
My question's for the professor.
Can you please introduce yourself?
My name is Baron Soka, Tech Freedom. My question's for the professor. You mentioned that you think that only the advertising platforms benefit from today's online advertising ecosystem, and that neither publishers nor advertisers do. And yet we see literally tens of billions of dollars being sent every year to online publishers as revenue. They depend upon online advertising for their revenue, so they're clearly benefiting. I don't understand your statement, given that real-world evidence and the fact that advertisers are spending that money.
I like that question. I was hoping for it. So the FTC has given an assignment to a group of researchers to investigate this. You can download the report from the site of the FTC. I think it was Alexi Acquisti with another group of researchers, and they found that the profits for publishers, so that's websites, is very low, like 1.5%. And now compare this to, for instance, contextual advertising. So there is no big profit there at all, to the big surprise of the researchers also. I'm not surprised personally, but they were. Then have a look. In 2017, Procter & Gamble stopped its digital personalized advertising. They withdrew first $100 and $200 million. 1 year later, their outreach was 10% higher. The New York Times stopped behavioral advertising in May 2018 because of the GDPR. 1 year later, their advertising in Europe, only in Europe. 1 year later, their advertising revenue in Europe had grown. If you look at how the ecosystem of real-time bidding and other that sort of systems work, and if you ask for evidence that it's actually beneficial for advertisers, there's also an interesting publication by investigative journalists, De Correspondent, also available in English now, that went inside the industry and talked to people, where basically the people who are building these systems said, look, we have no idea whether this works, no idea, no evidence, but if people are mad enough to pay for it, we go for it. So it's the same story that Vance Packer wrote in The Hidden Persuaders. The marketing department is very good at marketing, the marketing department of these intermediaries, which have been bought up by the platforms, yes. But the marketing departments of these intermediaries are very good in marketing their own software, but not necessarily in marketing the stuff of the advertisers, who are the people who are adding to the economy.
Last question, very short, please.
Very quickly. I just wanted to ask to the Commission, when is the Commission going to release a new set of standard contractual clauses, and will they extend to data processor and to the relation between data processor and data processor in the EU and abroad?
We are reviewing the international standard contractual clauses, but of course the idea is so that we do not have two separate sets and that we bound it together with standard contractual clauses under Article 28. So therefore it takes some time, but we are on it. I cannot provide you with an exact date, I'm sorry.
Okay, so I think we'll have to wrap it up. So just to kind of, at the outset I said there's a couple of objectives. Kind of one is with the upcoming review, get a bit of a better sense about what the process is. So, and I think the feeling from not from everybody, but for the majority is probably we should not reopen the GDPR. So then the point came, like, what are some of the things that need to be further strengthened? Enforcement. We, I think, had a big discussion on the enforcement side and some of the challenges there. The technology neutrality point is a strength. So if we're not going to reopen the GDPR, it will still be there. But I think with regards to some of the new technologies and the guidance around and the challenges around it is the need for maybe some more guidance from the authorities. The point about transparency and explainability about these new technologies, I think that's something that will keep coming back. And we'll see that also not just in the GDPR discussions, but, for example, the discussion around the machinery directive, the discussion around the product liability directive, and so the realization that the GDPR is not going to solve all of the issues in the world when it comes to new technologies, and we should also keep that in mind. Those were a couple of the observations that I had. Did I miss anything? You don't have to feel obliged to say something, but is there something that I really missed?
Well, I just want to emphasize this out-of-the-box thinking. Mireille just demonstrated that we haven't analyzed the business economical value of some of these practices, and maybe they should be analyzed, and if they're not necessary, to find a way for the society to get rid of them. So concentrate on technologies that add value to society and individuals, and not just technologies that make a lot of profit for a business sector without paying any attention to the effects and impacts they have.
Good. So I'll wrap it up here. Something tells me this is not the end of the discussion. I'm sure it feels like we're going to start this discussion now. So thank you for the panelists, thank you for the audience, and enjoy your lunch.